Hello. For those who have not had the pleasure of meeting, my name is Alan Gottlieb. I'm the founder and executive vice president of the Second Amendment Foundation, as well as the chairman of the Citizens Committee for the Right to Keep and Bear Arms. The two groups are the main sponsors of the 2021 Gun Rights Policy Conference, which just happens to be our 36th annual one, and boy have they grown over the years. This has been quite a year for the gun rights movement. Our opponents have thrown everything they can at us, plus the kitchen sink. I just want to remind you of one thing. It's like a football game where the rules have been changed. It doesn't matter how many points we score. If they score one touchdown, they win and we lose our rights forever. So that's why it's extra important that we be very vigilant and we keep fighting as hard as we can. Add to that, we had both in 2020 and 2021 a record number of new first-time gun buyers and gun owners. And those people are getting very heavily engaged in the gun rights movement. In fact, thanks to the Citizens Committee for the Right to Keep and Bear Arms and the Second Amendment Foundation is running national TV spots on over 20 networks. In fact, the foundation has run over 1,600 national spots and the Citizens Committee over 1,000. We've brought in several 100,000 new supporters of Second Amendment rights. The people buy their firearms, they now want to protect that right. It's really been a big banner year for the gun rights movement, and that's what makes this Gun Rights Policy Conference so extra important. We're going to reach more people streaming this online than ever before, and with your help, not only will we get more information and be able to share it, but we'll be able to take it and use it in the next coming 12 months to make sure that our gun rights are protected and extended. I just want to give you a warm welcome to this year's conference. It's an action-packed agenda, so let's get on with it, and thank you for participating. It's you that makes the gun rights movement what it is.
I ask a blessing, Lord God, upon this conference, upon each person watching me and listening to me right now. I ask, Lord God, that you allow your presence to be felt in this place, no matter where we are, even though we're separated by time and distance and time and space, that you would allow us to be on one accord with one another.
It is all of the millions of ordinary warriors like you and me across this nation, women and men too, who daily instill our precious and unique American constitutional values of liberty and freedom into each generation, who keep our homes, our neighborhoods, our cities, and our states safe by being responsibly armed citizens and teaching those things to our children and our children's children.
A while back, about a year, I ran into a member of the editorial board for Arizona Law Review 1 year ahead of me. That is to say, she was on the board that rejected my article. And she just said, back in 1973, your thesis was totally unacceptable. And today it's the law of the land. It must feel pretty good. It does.
When someone tells you you can own this type of gun or that type of gun, that's the illusion of freedom. Nobody's going to give you something they know you can defend yourself against them with, right? So they want to arm you with the illusion of freedom so you can believe that what you have is adequate enough to resist.
They say, look, we're citizens of the United States. The Second Amendment protects us. The Second Amendment protects the right to bear arms. And the 14th Amendment means that state and local governments have to obey the Second Amendment, and you still won't let us even get a permit to carry a firearm.
Was he not excusable for resorting to the natural right of self-defense?
Switzerland was surrounded on all sides by countries occupied by the Nazis or their allies. The Germans did have a plan called Operation Tannenbaum for the invasion of Switzerland. It was probably only abandoned due to Swiss topography and their known fierceness in protecting their own neutrality. There is an apocryphal story about Kaiser Wilhelm on a state visit to Switzerland. He remarked to a grizzled old Swiss sergeant major that his standing army was twice the size of the Swiss army, even including their reserves. Kaiser Wilhelm then asked the sergeant major what would happen if Germany should invade Switzerland. The old sergeant major thought on it and replied, well, the Swiss would then have to fire their rifles twice. And the Swiss do take their marksmanship very seriously. Every city, every town, every village has a shooting range.
My job as the head of the diversity shoot is to introduce you to firearms in a safe, inclusive manner where you can come, ask questions, talk to people, meet like-minded people, and become an advocate yourself and start pushing for your human right of self-defense. It bothered me. It bothered me that there are certain groups of people that think they speak for me based on my skin color. Well, that's the first generation of black man born in America with the same rights as anyone else after the 1968 Civil Rights Act. I'm the first generation, and I'm going to fight for my rights, all of them, and I'm not going to give them up because someone doesn't feel safe. You don't have a right to feel safe. You have a right to be able to defend yourself, your family, and your loved ones against anyone, including a tyrannical government.
Women learn how to talk to their kids about guns, how to choose the right firearms and gear to meet their goals, how to be safe in their anti-gun workplaces, how to get their carry license and training, how to get into competition, and so much more. And while many women come to us to learn self-defense, the best part is that they realize how much fun shooting can be. We have so much fun shooting together, and women find meaningful friendships. The instructors who run our events are respected and talented, and the programs we offer are fully comprehensive to help a woman protect her family and live her best life. I'm energized that 3.3 million of all the new gun owners last year were women, and a girl in the gun is ready for them. Please help us reach this new demographic so we can learn their stories and encourage them to share their journey with others.
The Second Amendment is extremely important. It was given to us by the framers. Actually, it was given to us by our Creator, God. However, the framers took that right that was given to us by God and enshrined it in law in our Constitution. We all are familiar with the Second Amendment. The Second Amendment provides every citizen with the opportunity to keep and bear arms. In fact, in many state constitutions, including the state of Michigan, the bearing of arms is not only for the defense of himself, but it's also for the defense of the state. Accordingly, I take that right very seriously, and I have dedicated my life to being a gun rights advocate.
The Republic is dependent on the future generation. This is why I've dedicated my mission to their safety.
All of us are capable of being influencers. We just have to be respectful when we speak up. You'd be surprised how many people agree with us. If we lose our freedom, it won't be because we lost the fight. It'll be because too many sat on the sidelines and forfeited the fight. Our opponents are doing everything to silence us. Their end game is to eliminate our freedom. That is what this is all about. Silence is consent. Silence is complicity. Silence is cowardice. Silence is the end of freedom. Are you going to be silent? I'm not.
This whole streaming thing, the whole gaming thing, it's mostly an untapped resource for us to help educate people who have some experience with firearms before, the anti-gun community tells them that they're bad for liking video games and liking guns because it involves guns. And that's just not true. And that's not fair to these kids. So from teaching gun safety to teaching activism, it's a great way to grow our community and help ensure that the Second Amendment is protected in the future. I'm really looking forward to the next year, as we're going to be reaching out to multiple content creators to kind of co-brand things and build partnerships that we found with a lot of them who are actually firearms enthusiasts. And we're even hoping to host a range day event with a bunch of streamers that we would obviously promote, teaching people, both those with experience as well as those without, just to try and grow it. You can catch us on Twitch as 2A Gaming, also updating the website at 2a.gg. Thank you guys so much for being here for this conference, especially being digital. I love it because that's kind of what I do. We're reaching more people, but that being said, it means a lot that you guys are here, and I hope you enjoy the rest of it.
In particular, I wanted to focus in on the pop culture component of this topic. And I want to tell you a little bit about my background as a self-taught amateur shooter who ended up going pro. And so this was about 10 years ago when I was a gun owner, but I was not a Second Amendment advocate at all. And for me, guns was just a fun thing I did on occasion, go to the range and punch some holes in paper, and then the guns kind of go back in the safe. And I really wasn't doing much other than target shooting at the time. Now, when Top Shot Season 1 started to air on the History Channel, it was such an important moment in my development and maturity and understanding of the gun community and of the Second Amendment. And so let me dive a little bit deeper into what I mean. Prior to Top Shot, the primary avenues where I learned about and saw guns was pretty much kind of movies, TV, the nightly news, which we all know is just frequently terrible with all sorts of crimes being committed with firearms, and is generally just overwhelmingly a negative perception and a negative experience with firearms. But Top Shot was this incredible firearms competition, and not just firearms, but just a weapons competition, bows and arrows, and throwing knives and throwing weapons, but then all the way to, fully automatic machine guns, grenade launchers. It was just an incredible experience to watch these normal, everyday Americans shooting some of the most fun and incredibly cool weapons out there. And so this pop culture component is so important because it portrays a positive image of responsible firearms usage. And so, I remember distinctly watching an episode in Season 1 of Top Shot where the competitors were shooting an AR-15. And as a civilian, I had never shot an AR-15, let alone an M4 or an M16. And so as an inexperienced, unknowledgeable, newbie, I just assumed that at the time that AR-15s and M16s and M4s and all fully automatic weapons were only allowed to be used by law enforcement and military, right? And so watching this challenge, though, of in Top Shot, right, I was watching civilians, right, shoot this AR-15 alongside military and law enforcement and all these other Americans from across the country, and it triggered this question in my head where I asked, okay, I'm seeing civilians shooting an AR-15. I wonder if I, as a civilian, can own one here in California. So naturally, right, I went down that rabbit hole of learning about, well, what is the process, here in California. And yes, right, I bought my first AR-15 after watching an episode of Top Shot on TV. And that was a very simple yet impactful way of educating Americans around, well, what are our gun rights and what's possible, right? Can I own an AR-15? And then, of course, as I purchased that very first AR-15, the first of many, I will admit, I learned here in California, well, we have all of these assault weapon regulations at the state level, and at the time, we required a bullet button. And then I was asking myself, well, wait, what is this bullet button thing? Why is it only required in California? And obviously it's now spread to other states or similar restrictions around assault weapons. And I just remember saying to myself, well, this doesn't make any sense. It's not an effective deterrent or way of stopping criminals, right? And so then one question leads to another. Why are my Second Amendment rights here in California restricted and less than Second Amendment rights in other states and other parts of our country? So the simple act of having positive representations of gun usage and gun ownership by responsible users is so important. When I won Top Shot back in 2012, I thought I was just gonna be, I'd have some, 5 seconds of fame and then go back to my day job in technology in Silicon Valley, and that would sort of be it. But it was really that moment of being on Top Shot that converted me into a Second Amendment advocate, where I realized that, guns aren't just about having fun. This is about our freedom. This is about what our country was founded on. This is about protecting our Constitution and pushing back against government and pushing back against gun control advocates and gun grabbers who are dead set on taking away our individual right to bear arms.
And I realize that not all gun owners are created equal. There are people that want to carry and that do not want to hunt. And there are people that want to hunt that do not want to carry. And none of us know what's going on with the shotgunners.
That what's considered newsworthy is not a very good, accurate reflection of what's happening out in the real world.
That's always been my driving force. What about the innocent person who's affected by these policies? That is what has driven me into this Second Amendment movement. It's not the guns, it's the safety. I hear people say, well, I wouldn't want a gun in my home because I have children. For me, I wouldn't want to be without a gun because I love my children and I want to be able to protect them.
The fire flares on the kitchen stove. You have to get to the phone, call for help. The dispatchers have to reach out to the fire service. The firefighters have to jump in the vehicles and head to your house. And if you live in a rural area, it's worse. You may have a volunteer fire department where they have to get on the phone tree, summon the volunteers to meet at the station, gear up, get in the vehicle. And by the time they get to your home, it's burned to the foundation and everyone inside is dead from thermal burns or smoke inhalation. And society figured out there's a fire extinguisher right there. You can kill that fire in its nest, and the only damage is you need a new stove, and there's a few $100 in smoke damage. It's exactly parallel with the defensive firearm. I've always taught the defensive firearm is a direct analog to the fire extinguisher. Each of those things is an emergency, life-saving piece of equipment geared for the first responder to use in a given life-threatening crisis. And society speaks of those of us who served in law enforcement, as I did for 43 years, or the fire service or the emergency medical service, as the first responders. No, we're the first official responders from whatever governmental agency it was. The real first responder is the ordinary citizen who is there when the deadly danger breaks out and has the best chance of smothering it and saving human life.
We will not compromise our rights to defend ourselves. There is an old saying, don't start none, won't be none. And that applies to all of us gun owners. At the end of the day, they will blame the object, not the individual. We need to hold the individual accountable. As responsible gun owners, we can do better. We are the ambassadors to the very object that they fear, the gun itself. However, with the right type of training, the right type of knowledge, you will be empowered to live another day.
It was really just a ploy to scare people and get them to support unconstitutional gun laws. By creating this type of fear, the hope of the anti-gunners was that fearful people would vote for the politicians who promised them safety. And of course, Democrats would promise to get these scary weapons off the streets. But first, you have to vote for them. And then you find out that they really have no intention of getting them off the streets in places like Chicago, Detroit, or Baltimore, because every death they can rack up and attribute to these scary guns is one more death they can use to push for more gun control on law-abiding citizens. Now, how about the term high-capacity magazine? There's really nothing high-capacity about 10 rounds in a magazine, but to people who don't own guns and don't know anything about guns, this is a scary term. The stuff like this works, and the gun grabbers know it. Let's not forget the big daddy term of them all. This is the one that's at the center of their anti-gun fear campaign. The term gun violence fuels the fear campaign. It's the go-to term. Without it, people might associate violence with the person who's actually committing the act of violence. We all know that gun violence doesn't exist. There's no such thing as gun violence. What we're really talking about is human violence, but politicians don't want to talk about human violence because it most often reflects poorly on their failed policies. If we were to talk about human violence, we would have to talk about open borders, sanctuary cities, gang violence, gun-free zones, defunding police departments, and the domestic terror groups like the ones that destroyed cities across America in 2020. We can't have that because that would reflect poorly on the politicians who benefit from the violence. And we certainly can't have law-abiding citizens standing up against the violence our elected employees often perpetuate. So the focus is always put on the gun. And what about the new term, ghost guns? Well, ghost guns is the new scary term designed to condition people into believing that guns should have a serial number and should be registered. You'll also notice a push for universal background checks in the pursuit of a national gun registry. Now, in 1791, when the first 10 amendments to our Constitution were ratified, I don't think there was a provision in there for serial numbers so the government could track the guns. Actually, the exact opposite was intended. In other words, government had no business knowing who had guns, where they were located, and they certainly didn't question the reason Americans owned them. They were there to remind the government who they worked for. Now, this terminology created by the gun grabbers is nothing more than propaganda pushed on people who don't know any better. After studying their strategies and marketing techniques, I felt it was a good area for me to get involved in, because if I can understand it, I can explain it, and if I can explain it, I can expose it. Although the strategies and terminology the anti-gun crowd uses are blatant, bold, and often obnoxious, they also use strategies that can be very subtle and many times go completely unnoticed, but still have an effect on the way we think about guns in America. An example of a subtle anti-gun conditioning is the accusation that no one needs a gun, or no one needs more than 7 rounds in their magazine, or no one needs to have a gun on them in public. The implication with these types of statements is that need should be a metric by which we measure our rights. I don't remember it being called the Bill of Needs, but if they can turn need into a requirement for gun ownership, who do you think would be in charge of determining whether or not you need a gun? The strategies used are very similar to marketing strategies that major companies use. For instance, if I said, "I'm loving it," you would know I was talking about McDonald's. If I said, "Just do it," you would think about Nike. By using scary anti-gun rhetoric, the general public develops a fear of guns and a hatred toward gun owners. That's their plan. The goal is to make people irrationally fearful of guns and unjustifiably hateful toward gun owners, all with the intentions of garnering more support for gun control. People are taught to believe that guns are dangerous and unpredictable, and that gun owners are recklessly and intentionally putting everyone in danger by supporting the Second Amendment. It's irrational. It doesn't make any logical sense, but it works. My job is to expose it and show people exactly what they're doing. In other words, expose them in public and let the world see their lies. At the same time, it's important that we gun owners change the narrative and bring it back to an honest, traditional American gun narrative. There was a time in America where guns were cherished by everyone because we all collectively knew how important they are to our freedom. Unfortunately, a portion of our society has been hijacked and misled to believe the exact opposite. I want to change that, and I'm willing to do whatever I can to expose the liars and bring new justice to gun owners across this country. Our founding fathers saw these gun grabbers and tyrants coming over 200 years away, and that's why the Second Amendment was written. I'm Dan Wass, and the Second Amendment is not a privilege, it's our right. It's also our responsibility to protect and preserve it.
To have my basic human right of self-defense taken from me after going through something so horrific. I mean, a stalker murdered my husband in front of me. I want to be able to protect myself. That's very important to me.
And so to me, this is one of the biggest firearm media stories of the year. It's not what they're reporting, it's what they're not reporting. All right? Because they want to do their part to keep the gun control push alive. It doesn't do any good if President Biden's pushing an assault weapons ban and CNN's going, well, that doesn't work in Chicago or New York City or California. See, that won't work, so they can't cover it. All right? So to me, that is a huge ongoing story, a huge ongoing narrative. Now, if I think about something very positive that happened this year, and it did get coverage, not that the coverage was good, but it did get coverage. The Fourth Circuit's decision against the ban on 18 to 20-year-olds buying handguns. Was that not phenomenal? The Fourth Circuit, led by, in the majority opinion, Julius Richardson, that justice noted that, look, if you look back through American history, there was not a limit that you had to be 21 in order to own a gun or do whatever. And he points to the importance of the age of 18 and how important that was in the minds of some people, and also relies on history as it relates to the militia, and talked about how people who were considered adults, and again, that's going to be your year 18, that those people, able-bodied, were expected to be ready to have guns in case they were called together, called to band together, as James Madison talked about in Federalist 46, call to band together for defense of their town or defense of their nation. And so Justice Richardson kept looking at these things. He's going, look, historically 18 to 20-year-olds, they're not banned from enjoying these constitutional rights. So they struck down the federal law there, or the rule against 18 to 20-year-olds buying guns. And I should be clear, they didn't strike it down, they remanded it. So it'll go back for more consideration at a lower court. But folks, that's a huge story. Huge, all right? I mean, since when does a bureaucrat get to pick which constitutional rights you do and don't get to exercise at age 18? That's what it boils down to. All right, so this is all about freedom.
And they peddle these things because that's what they're told is the truth. They don't do any investigating of their own. They don't know the facts surrounding it. They just regurgitate whatever they're told by these so-called these so-called fact checkers and communications directors and those who create talking points at gun control groups.
In this world, it's crazy, but it's your outlook that really matters. Your point of view. Life is tough. It takes a pounding. But our ability to stand back and see where all this ends, I don't have it. I don't know that you have it. So we're in there, we're fighting, keep fighting, and then look in the mirror and say, I want to be like you, because you're fighting the good fight.
Over the years, law-abiding gun owners in the United States have endured as little by little our right to keep and bear arms has been infringed. We have already seen various accessories and gear, types of guns, and magazine capacities become banned. And with more and more gun control comes less and less freedom. So what happens if and when they do come to take our guns? Have you thought about what you will do? Have you made a decision, and have you come to terms with it? Many people in the firearms community refer to the mysterious boating accident in which all firearms were lost. But we all need to seriously consider our real course of action, and that's why America must do something now. If we continue to compromise or try to ignore the attacks on the Second Amendment, if we sit back and simply hope that someone else will contact representatives, influence others, and make their voices heard, we may eventually find ourselves with nothing left. No more normal capacity magazines. No more AR-15s. No more semi-automatics. No more handguns. Soon, the firearms and the options to protect what we love could be gone. Just like that. I realize that this can be a tough decision, but remember why we have the Second Amendment in the first place: to protect us from a government that would choose to infringe upon our right to keep and bear arms. Consider what Thomas Jefferson wrote. Whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it and to institute new government. Or what about Martin Luther King Jr.'s comment in his famous letter from a Birmingham jail? One has not only a legal, but a moral responsibility to obey just laws. Conversely, one has a moral responsibility to disobey unjust laws. So comply or not. Become an outlaw or not. Whatever you choose, be sure to weigh the risks and the benefits and be prepared to face the consequences. Don't wait for someone else to speak for you or to do something for you. The world all around us, especially over this last year, has shown us countless defining moments that prove why the Second Amendment and our individual right to self-defense is so important.
You know, and it's like, give me a break here. I mean, exactly what are they trying to say and do here? It's mind-boggling as to what is going on here in this country with regard to this. But I think the outlook is very good. You know, as I said, the Supreme Court, I think, you're going to see some rulings here that will be very favorable to the Second, Amendment and the 2A movement. If you're looking for places to look for news, I think, most of you out there are probably pretty well versed with that. But I do want to give you some bit of advice here with this, is that do not always just, wrap yourself around in conservative /2A, pro 2A websites and news organizations and things like that. You need to get a little bit of the other side in order to be able to find out what they're doing and put together a reasoned argument.
Remember, voting has consequences. You're never going to find the candidate you agree 100% with. If you do, share the wealth, let everybody know so we can move them to higher office. We want them so we all can get along. But you're very rarely ever going to find that 100% person you agree with. In the military had something we call the 80% solution. That's a good plan now is better than the perfect plan tomorrow. Would you rather have somebody in office that you agree with 80% of the time, or not vote or vote for the opposition because you got hurt by some tweets and now you've got somebody that their gun policy is 100% against what you think?
Commentary is important. Opinion is important. It's important to have smart people discussing issues and sharing their views of things. But it's also very important to break news, to tell stories that aren't otherwise being told. And we have far less of that out there in the gun community than we do the former.
And we have a really good opportunity now to press our case. Not only the constitutional case against gun control, but the pragmatic case against gun control.
I'd like to thank the ATF for making it possible for me to write a column calling on Congress to abolish the ATF. They helped us tremendously, the ATF did. The story chronicled their foibles over the years, Ruby Ridge and, of course, Waco, and showed how the administration is weaponizing them now for even more harm to gun owners. A lot of stories we did, of course, were about Joe Biden's nominee for ATF, the little fella that is David Chipman. And just like ATF, Chipman is helping making those stories possible, too, because he is, what he is. And I'll just leave that at that.
Hi, I'm Mark Walters, host of Armed American Radio, Armed American Radio's Daily Defense, co-founder of Armed American News, and a very proud member of the board of directors of the Citizens Committee for the Right to Keep and Bear Arms. As such, from that perspective, I'd like to welcome each and every one of you to this year's virtual Gun Rights Policy Conference. I know while we can't get together, I know a lot of us are wanting to do that, and I'm sure we will in the near future. At least we can gather here virtually and bring the talk about gun rights to a virtual audience and probably reach a lot more people than we could if we were in a hotel conference center, quite frankly. I've got the media perspective is my topic every year. And usually, most of you who have seen me speak here know that I generally wait for somebody to throw me something, a thought that comes to somebody, it just comes to me. This year, that didn't happen for the first time in many years. Why? Well, actually, I guess I could say it did happen. There were just too many of them. Let me put it in that perspective.
In sum, the ability of various levels of government, federal, state, and local, to operate as checks on one another has a very little bit of case law, a little bit of constitutional background, a lot of money involved. And finally, the political reality of divided government and pressure that can be brought to bear on elected officials is probably the most overwhelming. With only a couple relevant U.S. Supreme Court cases, it's clear that our ability to urge state and local officials to work in favor of Second Amendment rights rather than against them comes primarily from the power of the voices of their constituents and not from federal and state judges. Thank you very much for giving me the opportunity to speak on these important issues.
Hello, my fellow patriots. My name is George Lee, and I'm an attorney with the firm of Seiler Epstein LLP in San Francisco. I was lead counsel for plaintiffs in the case of Miller versus Bonta, a challenge to California's assault weapons ban, which we filed in federal district court in San Diego. It was my privilege to represent plaintiffs such as Second Amendment Foundation, Firearms Policy Coalition, San Diego County gun owners, and other organizations and individual plaintiffs. And my thanks go out to all of you who have supported these organizations throughout the years that made cases like Miller possible. Miller was a historic and important win for firearms rights. It was the first time that gun rights prevailed at the district court or the trial court level in a challenge to a state's assault weapons ban. It was also important because we were finally able, using evidence, to dispel many of the myths that surround so-called assault weapons, as that term may be used by various state laws. So if you're a fan of Adam Kraut like I am, you might appreciate it when I say we were able to crush some of the many myths that surround so-called assault weapons. And today I'd like to tell you about 3 of the myths that we were able to successfully dispel using evidence in court in the Miller case. So the first myth that the state continued to propagate in defending and justifying its law was that somehow the existence of these generic assault weapons characteristic features such as flash suppressor, pistol grip, collapsible stock, that somehow these features made a semi-automatic firearm more inherently dangerous than other semi-automatic firearms. As the state was claiming in its pretrial submissions to the court, in which it was arguing that assault weapons are inherently dangerous, it claimed that each of these features serves, quote, specific combat-oriented functions which increase the lethality of firearms and enhance their effectiveness in certain types of crimes, particularly mass shootings and violence against law enforcement personnel. But we showed at trial that this is simply not true. One of the things that we admitted into evidence at trial was a video taken by our friend Adam Kraut, in which he fired the same rifle in 2 different configurations. First was California legal configuration, and it was legal under California law because it lacked those features such as the flash suppressor, pistol grip, or collapsible stock. Second, he took that same rifle and simply reattached those features into the standard AR-15 configuration that you're familiar with. What he was able to demonstrate using this video is that he was able to hit a man-sized target at 25 yards effectively and rapidly with no material difference. He was even able to perform a magazine change between the 2 different configurations with no material difference in the time that it took for him to do so. The trial judge thought that this video was particularly interesting and helpful in demonstrating that the existence of these features, although they may be important to a law-abiding average citizen to whom accuracy and ergonomics and training may be vitally important, to someone who is intent on committing indiscriminate killing or some type of other crime, the existence of these features made no material difference.
I've been hired also by the Second Amendment Foundation to assist with a case in Montana where the regents that run the universities in Montana, the state universities of Montana, believe that they can override Montana state law and forbid firearms on campuses when there is no Montana law allowing them to do that.
So what are the key arguments? Well, we start with the text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed is crystal clear. Then, as now, the word bear means to carry. You can see that in Samuel Johnson's definitive dictionary. You can see that in Noah Webster's dictionary. That should really be the end of the matter. But it's likely the Supreme Court will also look to history, and the history is equally clear. We can start with the practices of the founders. George Washington frequently carried firearms for his personal self-defense. So did John Adams. John Adams also acknowledged during the Boston Massacre trial that there was a right of ordinary law-abiding citizens to carry a firearm. Thomas Jefferson told his nephew, "Let your gun be your constant companion." James Madison carried frequently, as did James Monroe and John Quincy Adams. The choice for the United States Supreme Court could not be clearer. Either the Supreme Court brands the first 6 presidents of the United States of America as habitual criminals, or it acknowledges that the historical tradition was such that there was a right to carry a firearm for the purpose of self-defense. And it wasn't just the practices of the founding generation, it was also the laws. There is no law at the time of the founding that prohibited ordinary citizens from carrying. There are other laws that in fact mandated carriage in many states at the time of the founding. There were also laws that prohibited slaves from carrying a firearm. Why would you need a statute prohibiting slaves from carrying a firearm if nobody had a right to carry a firearm? The one thing the other side points to, the state of New York, is the Statute of Northampton. This is an English law from 1328. You heard me right, from 1328. Now you might say, what is the significance of a law that is 700 years old from another country? Well, there were certain jurisdictions at the time of the founding that had a law that was somewhat analogous to the Statute of Northampton. But they were very clear, clearly understood, only to apply when carrying was done to terrify people. The case law is very clear about that, and the practices of the founding are also very clear about that. We can see that there is a right to carry a firearm for law-abiding citizens from the purposes identified in Heller as well. It's not just the text and the history, but the purposes of the Second Amendment, which include the right to self-defense, which obviously requires the ability to carry a firearm outside the home. We can see it from the right to fight tyrannical governments. Obviously, the battles of Lexington and Concord were not fought in people's living rooms. And we can see it from the right to hunt, which again, obviously takes place outside of the home. The bottom line is that the text of the Second Amendment is clear, the history is clear, the purposes are clear, and the plaintiffs should prevail in these cases. And if they do, tens of millions of Americans will have their constitutional rights honored and restored. Thank you.
A gentleman in public housing outside of Nashville. He had a firearm in his home, which was against the lease, and when he had to defend himself because he got attacked by someone with a firearm, they threw him out. They argued that violated the lease, and so we are on appeal now. Staff, again, is sponsoring his appeal in Tennessee State Court. A federal case is also imminent because someone who is of limited financial means and needs to avail themselves of public housing shouldn't sacrifice their constitutional rights as a result.
Significantly, the issue in both Massachusetts and New York is whether or not a handgun license is issued with restrictions. And a license that is issued without restriction generally authorizes the carry of an operable handgun in public, and the significance being that in both Massachusetts and New York, the handgun license that's being issued is generally needed to purchase and possess handguns in the first place. So in Massachusetts, even though licensing decisions are being made at the local level, the actual physical license cards are being issued by the state, and they're included in a central database, so we're able to see how many licenses have been issued with restrictions and without restrictions. And what we can see is that throughout all of Massachusetts, just over 91% of licenses were unrestricted in 2015, and 6 years later in 2021, nearly 96% were unrestricted. So it has really become a situation where there's only a handful of licensing jurisdictions that are problematic, that are routinely issuing licenses subject to restrictions. In New York, most licensing decisions are being made by county judges who are elected, but it is often also the case that individuals involved in local politics, including the county legislature as well as the sheriff's department, may make significant input on what local policies should be. So in Putnam County, which is very close to where I live, for a period of about 10 or 15 years, local authorities were normally issuing restricted handgun licenses. There was an organized campaign to elect a judge that would be more protective of people's Second Amendment rights, Judge Reitz, and the result of that is that now in the normal course, people in Putnam County are able to obtain unrestricted licenses, although they may have to wait some period of time, a few months, and take a class to do so. In Erie County, on the other end of the state, they had historically, Erie County has normally issued restricted licenses, in no small measure due to efforts by Lieutenant Governor Kathy Hochul back before she was Lieutenant Governor. They adopted a system several years ago under which people who have held restricted licenses for 5 years can apply for unrestricted licenses. Obviously, 5 years is a rather long period of time to be denied your constitutional rights on the one hand, but on the other hand, this does reflect a significant improvement from the prior practice in Erie County, and it should perhaps be noted that it appears that Kathy Hochul will likely be our governor in the near future.
Let me tell you about one of the cases that I'm working on right now called Kendrick versus Graywall. It's a case that's pending in the United States District Court for the District of New Jersey. And one thing I really like about this case is I like to call it a big tent lawsuit. That's because it includes a whole series of organizations all working together, a whole bunch of Second Amendment groups. It's not just Second Amendment Foundation, it's also Firearms Policy Coalition, Association of New Jersey Rifle and Pistol Clubs, which is the NRA State Association for New Jersey, Coalition of New Jersey Firearm Owners, New Jersey Second Amendment Society. So it's nice to see a really broad coalition of groups like that, and I'm very glad to be part of it. So this is a challenge to New Jersey's firearms permitting system. I'm not talking about carry permits. Everybody knows that New Jersey has an extremely onerous carry permit law. I'm talking about the basic system for permitting to acquire and possess firearms. Just the basic right to possess firearms. And to be clear, this is a system that puts real obstacles in the way of the exercise of the right to keep and bear arms. We're talking about multiple forms, fingerprints, background checks, references, delays, appeals in court, that kind of thing. This process has lots of hoops to jump through in order to exercise one's constitutional rights. This is a mess. Now, the way the system works, New Jersey has two basic types of permits just to acquire and possess firearms. There's the Firearms Purchaser Identification Card, usually called the FID card, and what's known as the Permit to Purchase a Handgun. Now, the FID card is required for a number of things, but mainly it's to acquire and possess long arms, rifles and shotguns. As you probably guessed, the permit to purchase a handgun is a permit that you require to acquire a handgun. Now,
The thing is, every time you want to acquire a new handgun, you have to go through the process all over again. So you need a permit every single time you buy a handgun. So you have to do the entire process, start to finish, for each purchase. Now, the process for the permits, for both permits, is essentially the same. There are several substantial forms to fill out. You have to answer numerous questions. You have to obtain fingerprints from the state-approved digital fingerprint provider at substantial cost. You provide 2 references. The police do a very substantial background check. This process can and does take months, very often. Now, we've documented through the Association of New Jersey Rifle and Pistol Clubs Permitting Strike Force project enormous delays throughout the entire state, sometimes lasting more than a year. So this presents real hoops to jump through just to exercise a fundamental constitutional right. So what the lawsuit does is it asserts that it is a violation of the Second Amendment to require a pre-approval process like this that stands in the way of the exercise of a fundamental constitutional right. I mean, it's that straightforward. Now, what's notable about this is that New Jersey sees that as a feature, not a bug. New Jersey is proud of the fact that New Jersey law makes it difficult to exercise the constitutional right to keep and bear arms. This is something that New Jersey wears proudly on its sleeve. Now, we've seen that the deprivation of this fundamental right can literally be fatal, as we saw in the very tragic Carol Baumann case. Carol Baumann was knifed to death in her driveway by her violent ex-boyfriend while she was waiting for the police to approve her permit application.
Young is a challenge to Hawaii's handgun carry laws. We started the case back in 2012, and my client, George Young, filed the case pro se. After applying for either a handgun carry permit to carry openly or concealed. After he was denied for both, he filed suit challenging both provisions of the law, and he alleges in his lawsuit that he would like to carry one way or another and does not have a particular preference as to the manner that he carries. He simply wants to carry in some fashion, be able to defend himself when he leaves his home. In Hawaii, originally, you have to show an exceptional case for concealed carry, and as a practical matter, open carry meant to carry just for security guards.
But the premise of the argument has to be that what is on the internet is not speech. Or if speech is speech of a character that is not protected. And that's where your problem comes in, as far as I'm concerned, because they are still prevented, chilled, by the possibility of being sent to jail because of this regulation, right?
Your Honor, as to your question about the First Amendment and what is and isn't speech, I think the issue is that Defense Distributed hasn't given this court the ability to rule on that issue because they never filed for a preliminary injunction in the district court, as we understood that they would, and as they told the Western District of Texas that they would. They filed their Second Amendment complaint, but no preliminary injunction followed. And so therefore, without that satisfaction of Rule 8, this court has no record on which to determine whether the district court did or did not commit error in fact-finding. And fact-finding is necessary to reach the conclusion on the First Amendment because we, as the New Jersey Attorney General, would have to put in evidence about what compelling state interest there may be on any level of scrutiny with speech.
But you can't regulate speech, any kind of speech, just because you say you have a compelling interest.
Well, certainly some speech can be regulated.
Yeah, well, that's the whole point here, isn't it? And New Jersey has yet to have to argue about that. And you say, oh yeah, take the case to New Jersey, and then you'll, then they'll be litigating in two forums again, won't they? But anyway, I repeat myself.
Your Honor, just on that last...
No, I appreciate your argument. You've had at least 5 minutes extra, and I don't mean to disrespect your position or that of your state, except to say you've had more than enough time.
Thank you, Your Honor.
All right, thank you.
The upshot we have is that for Second Amendment advocates who are most right on the merits, you can expect your opponents not to join issue there in substance, but to use procedural gamesmanship, and that the way to attack that is with patience and persistence. We are cautiously optimistic about this case and look forward to the court's ruling. The YouTube website of the Fifth Circuit has the full argument, and we commend it to everyone.
This is wrong, and that not only should courts not be applying intermediate scrutiny in Second Amendment cases, they really shouldn't be applying one of the tiers of scrutiny at all. And I want to begin with the history of the whole tiers of scrutiny framework, because I think it helpfully shows that this doctrinal approach is not solidly rooted in the Constitution's text or original meaning, and in fact is inconsistent with it. At the founding of the nation, for most of American history, really up until the mid-20th century, courts did not apply any of the tiers of scrutiny, strict, intermediate, or rational basis review. Instead, courts basically just tried to figure out what the scope or boundaries were of the government's power and of the Constitution's restrictions on the use of that power. And then if they determined that the law or government action that had been challenged transgressed the boundaries drawn by the Constitution, then that challenged law or action was unlawful. And it wasn't really until the mid-20th century, again, that the tiers of scrutiny approach began to take shape, and it was at that point that the Supreme Court began using the strict scrutiny doctrine in First Amendment cases. And even then, it wasn't as though the justices on the court had uncovered some new historical research or evidence indicating that strict scrutiny was the most faithful way of interpreting the Constitution. Instead, the strict scrutiny doctrine, and then later intermediate scrutiny and the rest of the framework, were adopted essentially as a political expedient to bridge the various factions on the court at that time, and they were adopted as a way to uphold laws challenged under the First Amendment, even though those laws appeared to fall within the scope of what the First Amendment protected and didn't allow the government to infringe. So essentially, strict scrutiny, although it's now considered the strongest of the tiers of scrutiny, was really adopted initially as a way of balancing away our First Amendment freedoms. And I think this history indicates that the tiers of scrutiny were really not adopted because they were thought to be consistent or faithful to the Constitution's text or original meaning. And in fact, I think the history shows that at least for most constitutional provisions, the tiers of scrutiny approach is contrary to the text and original meaning of the Constitution.
Constitutional litigation is often binary. There are two outcomes, right? The Supreme Court will pick one of two competing readings of the Constitution. For example, in Heller, the Supreme Court held that the Second Amendment protects an individual right to keep and bear arms. But the dissent disagreed. The dissent said the right was collective in nature. Was Heller correctly decided, or did the dissent have the better argument? Heller was a case of first impression. There was no precedent that the court could rely on. Rather, the court was interpreting the Constitution from a blank slate. The majority and the dissent considered a wide range of factors: text, history, structure, practice. No single factor was dispositive. It is tough to grade the accuracy of such complex decisions in their entirety, but we can focus on part of it here in my brief time. Heller relied on textualist arguments. That is, what is the meaning of the text of the Second Amendment? Now we have a new way to assess how accurate the majority and dissent were. We have a tool called corpus linguistics. Corpus linguistics. Linguistics meaning language. And corpus means body, right? Think of like the body of Christ, Corpus Christi, right? We have these databases, these bodies of language, these systems that index how language is used. Corpus linguistics is a method for studying how language is used. And corpus linguistics allows us to assess the accuracy of Heller and the Second Amendment landmark decision. The Second Amendment provides a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. As we all know, Justice Scalia wrote the majority opinion in Heller, and he concluded that the Second Amendment protects an individual right to possess a firearm unconnected with service in a militia, and to use that arm for traditionally lawful purposes such as self-defense within the home. In short, an individual right. Justice Stevens dissented. He contended that the Second Amendment is most naturally read to secure to the people a right to use and possess arms in conjunction with service in a well-regulated militia. That is a collective right. Justice Scalia and Justice Stevens each made linguistic claims about 4 elements of the Second Amendment. Number 1, right of the people. Number 2, keep and bear arms. Number 3, keep arms. Number 4, bear arms. Both the majority and the dissent used various textualist approaches to consider these 4 phrases. But their toolkit in 2008 was limited. They considered only a fairly narrow range of sources to interpret the text. Justice Scalia admitted that his analysis was limited to the written documents of the founding period that we have found. Likewise, Justice Stevens' dissent cited dozens of contemporary texts, dozens. Over a decade later, big data allows us to perform much more sophisticated queries. Our work relied on the corpus of founding era American English. The corpus of founding era American English is abbreviated to COFEA. COFEA, C-O-F-E-A, it rhymes with Sophia. COFEA contains over 100,000 texts of approximately 140 million words. That's a lot of words. And it covers a very important time period, from 1760 to 1799. Why those years? King George III's reign began in 1760, and George Washington died in 1799.
ATF published its first proposal to impose NFA control on stabilizing braces over the 2020 holiday season and left only 17 days for public comment. This action violated congressionally mandated rulemaking requirements, and so SAF challenged that rule on procedural grounds in the Northern District of Texas, Dallas. The parties were scheduled to exchange cross motions for summary judgment, but then the Biden administration issued its gun control actions in April of this year, which gave the Justice Department 60 days to issue regulations on stabilizing braces. And so the Justice Department requested, and we agreed to, a stay to suspend proceedings in the district court because of ATF's impending publication of the proposed rule, which is the very rule I'm here talking about today. As reflected in the proposed rule, which was published by ATF on June 10th of this year, ATF seeks to reclassify millions of stabilizing brace-equipped pistols as subject to the NFA, which would trigger NFA paperwork requirements, taxes, long wait times, and transfer restrictions for the affected firearms. ATF's proposed expansion of NFA control will not only impact how new guns are equipped with stabilizing braces, but would also affect millions of existing pistols lawfully in private hands that are equipped with stabilizing braces. The NFA was not amended for these changes. Instead, ATF decided to change the scope of the NFA on its own. Central to its plan to expand NFA control, ATF's proposed rule sets forth a point scoring scheme for use in applying the NFA restrictions. The scoring scheme is non-exhaustive, vague, highly subjective, and it overcomplicates what is already an overcomplicated matter. Under the point scoring scheme, a pistol must not be too long or too short. It must not be too light or too heavy. A configuration can be penalized for having sights and for not having sights. And while ATF provided 3 examples in the proposed rule to illustrate its proposed brace and firearm scoring methodology, the examples instead illustrate how seemingly identical firearms can be subject to vastly different government controls.
Like the federal handgun purchase ban, this is a law that is very difficult to understand as a practical matter. Open carry generally is allowed in Pennsylvania outside of Philadelphia, so despite the fact that 18 to 21-year-olds are not eligible for carry permits, they generally can open carry. But open carry rights for all citizens are taken away during a declared emergency, and Pennsylvania has been under declared state of emergency due to the opioid crisis since 2018. The effect of this is that 18 to 20-year-olds are flatly banned from carrying handguns in public, despite them typically being able to open carry lawfully, even without a license. The district court upheld the ban, and we currently are briefing the appeal in the Third Circuit.
Fortunately, the legal landscape has become less hostile since the time those district court opinions issued, as the Supremes have reined in some of the more far-reaching power grabs by states, with opinions that make clear the government cannot simply place a moratorium on the exercise of fundamental civil liberties in the name of regulating public health. That's much better than where we were a year ago, when many lower courts were acting like the government's power to regulate in the name of COVID-19 was essentially unbridled. More generally, our chances of getting the Second Amendment rights on the same footing with the other enumerated constitutional rights largely rest with the case that the Supremes have already agreed to hear and decide, New York State Rifle and Pistol Association versus Corlett, which is shaping up to be the most significant Second Amendment case of the year, and perhaps the most significant since Heller. This case involves the constitutionality of the New York law that bans all open carry and only allows concealed carry upon demonstration of a special need for self-protection. That is, something more than a general desire to carry a concealed weapon to protect one's person or property. That question inevitably puts before the court many of the core underpinnings of the unanalytical frameworks that lower courts have been applying for years now, and treating the Second Amendment as a second-class right, one worthy of less protection and subject to greater governmental restriction than other rights. As the plaintiffs contended in their petition for certiorari in that case, quote, the refusal of some lower courts to meaningfully engage in the textual and historical analysis that Heller requires is not confined to cases involving the right to bear arms outside the home. Time and again, courts have effectively replaced Heller's textually and historically grounded analysis with a loose form of interest balancing in which the state always wins. Repetition of an error does not cure the error, it just heightens the need for the court's review. End quote. Well, the plaintiff's petition for cert was granted, so let's hope that means at least a majority of the Supreme Court will agree. In all events, though, as the plaintiffs explain in that case, regimes like this purport to, quote, ration constitutional rights instead of protecting them, when government may not reserve to a select few what the Constitution guarantees to all, end quote. That is what we must continue to press in pushing back against efforts by the government to trample on the Second Amendment throughout this pandemic and beyond, as that is the only way to ensure this right is placed back on equal footing with the other enumerated constitutional rights, like the free speech and association rights, which are much more readily recognized and respected in our system. And that is the only way to ensure that this right is treated as the fundamental civil liberty that it is.
Hi, I'm Mark Smith from the King's College in New York City. In this era of defunding police departments and reimagining policing, the idea that each of us is our own first responder has really taken on greater significance than ever before. Now, some folks, our neighbors, are beginning to understand, I think, for the first time, that the police simply cannot be in all places at all times, and that you alone are responsible for protecting your life and the lives of your family. But the idea that you and I are our own first responders is actually not a new concept in American life.
Good morning, everybody. Welcome to the Gun Rights Policy Conference. My name is Dave Kopp. I'm the president of the Arizona Citizens Defense League, or ACDL. My topic today is state-level activism, more specifically, how to win at getting things done at the legislature in your state. Job one, don't lose. It sounds obvious, and most of us are probably thinking, well, of course not, why would you lose? But no matter how many good bills that you can get introduced, no matter how many good things you can get signed by the governor, you get one assault weapons ban that slips through and you lost. All of us are familiar with the litany of garbage that we get thrown at us every year. Assault weapons bans, red flag laws, enhanced or expanded background checks, etc., etc. You can't have those pass. It will ruin every good thing you did. So, job one, don't lose. Establish good relationships, especially with your legislators, but not only your legislators. Legislative staff is very important. Can't get in to see a legislator if the staffer at the front desk hates you. Security at the buildings. We all went through the lockdowns this past year. Can you get into the building? Maybe if you're friendly with the security, you can get past when others can't. Good relationships are always key. With your legislators, you need good sponsors. You need good, solid committee chairs that you can talk to and make sure you get your bills on the agenda. You need relationships with leadership so you can get those bills on the floor. Relationships are key to everything. You can't lobby without good relationships. Support structure. Most of us are type A personalities. Most of us are not real good at taking advice or instruction from others. It's important that you get help. It's important that you take it when you get it. Who do you surround yourself with? Do you have other state level groups that work for the RKPA that you can depend on, that you can talk to, that you can exchange ideas with? Let's hope. But if not, start one. You know, just because you have already started a group doesn't mean you can't have more. Support structure is just so important. We need at all times to be helping each other out. Second Amendment Foundation gives us this platform so that we can talk to you about these things. That's our support structure today. We support Second Amendment Foundation. They support us. Just as an example, we have other state level groups. We have other national level groups that we can reach out to that can give us advice and opinions. Use every resource that you have. Your support structure is key to everything. Another important part of the legislative scene, make sure you know how to pick your battles. As a buddy of mine once said, know what hills you're willing to die on. Not everything is going to get through. That's just the reality of legislative sessions. You could maybe introduce 8, 10, 12 bills and maybe only 2 or 3 of them get through. In the end, you have to be willing to accept that. All of us, again, type A personalities, these are our babies. We shepherded these things through. We worked so hard for them. You want to see them all passed and signed. It's not going to happen. And, you know, sometimes maybe you get lucky, you do get them all done, but don't look for it. It's not going to happen most of the time. Be willing to take a loss here and there for a win in the long run. If you can get 2 or 3 of your most important bills out of a package of 10, you won. Follow through. One of the most important things, whether in legislation, in sports, whatever, follow through. Just because you got a bill passed and signed doesn't mean you take your marbles and go home. It goes back to those good relationships we were talking about. You need to go to that sponsor. You need to thank him for all his efforts. You need to make sure he's lined up to do it again for you next year with a different bill. You need to go to the folks, as we mentioned earlier, that you didn't get through. You didn't get all the way to the finish line. Hey, we worked hard for you. We'll work hard for you again. We'll try it again next time. You need to make sure that you talk to everybody that you were involved with, your support structure, your legislators, your staff. Thank everyone for their efforts. Make sure they understand that you're going to be back. Follow through. It's a process, not an event. You aren't one and done. You didn't come, win, leave. You'll be back next year. You'll be back a year after that. Make sure everybody understands that. Want to thank you for your time. Hope this was helpful. And I hope to see you all again, hopefully live next year. Thanks again.
Our top priorities this session include constitutional carry and limiting emergency power. Constitutional carry has been the brass ring for Ohio ever since passing concealed carry in 2004. 21 states have constitutional carry, including 2 of our neighboring states. This represents over 40% of the country. Now, every time we want to change the law, the gun grabbers panic. It happened with concealed carry, it happened with Castle Doctrine, it happened with removing the duty to retreat, and it's going to happen with constitutional carry.
We will be expanding our lawsuits into other localities once we're through with Winchester. Certainly Richmond is ripe for this. They put up signs around Capitol Square on the streets in that area, and it says no guns, and I kid you not, in very fine print at the bottom it says, well, this sign only applies if there's a permitted or should have been a permitted event going on. So you've got to read all the way to the bottom, and you have to be a fortune teller to know if there's a permitted event or one that should have been permitted. That's even worse. 10 people get together and they're walking down the sidewalk, and the police could say, oh, well, that should have been a permanent event, that many people walking on the sidewalk. So that's unacceptable. And Richmond is playing a dirty game there of chilling rights because people see that sign, they're afraid to carry. They don't want to violate the law, even though they wouldn't be unless there was an event or a permanent event going on in that general area around the General Assembly and so forth, or anywhere that they're having a permanent event. But they put those signs up permanently in that area. Really, really, really despicable. So that's where we are. We've got a lot going on in Virginia. Like I say, elections are going to be critical. I think the nation will be watching what happens here. I know Virginians are fed up with all this gun control and everything else, all the other insanity that we're all seeing across the nation. And so we will keep the fight up, and I appreciate the opportunity to talk to everybody. Wish I could see you in person. Thank you very much. Good evening.
Welcome to the 2021 Gun Rights Policy Conference from sunny Florida. I'm Rich Naskak, founder and executive director of Florida Carry, the largest independent self-defense rights organization in the state. The very first time I spoke at Grpc was in 2012 in Orlando. Florida Carry was a fledgling organization, having only been chartered for a year. And I met Alan Gottlieb for the first time. And although he was cordial, Bowtie Guy commented that he'd seen state organizations come and go, and time would tell if Florida Carry had staying power. I'm honored to announce this year marks Florida Carry's 10th anniversary. Today I'm going to speak about state organizations in general, and specifically what's been going on in the gunshine state. No matter how much money a national level organization has, it can never muster enough resources to handle every state gun rights issue. State organizations like Florida Carry perform a vital role, as individual states are the daily crucible in which restrictions on rights are tested. It is here that we have traditionally seen the gun control lobby test their legal theories, including universal background checks, magazine limits, age limits on purchases, and a host of other restrictions. Until recently, those initiatives have been largely in response to specific shooting events. But the tone has now changed to reflect an alleged epidemic of gun violence. Primarily, state organizations fight on two fronts, in the legislature and in the courts. As important as it is to prefer new pro-gun legislation, state organizations must carefully scrutinize pro-gun bill language to ensure that no poison pills exist, and must lobby to have sponsors amend the bill to eliminate them if they're present. For example, a simple pro-gun rights bill filed this last session, HB 259 by Representative Cord Byrd, was intended to level the playing field among churches with regards to self-defense. Under Florida law, churches are considered private entities and as such decide for themselves if firearms will be allowed at services. Unfortunately, not all churches could do that. But the bill language had a poison pill. It's been long accepted in Florida that no firearm signs have no legal weight and do not suffice as legal notice for purposes of trespass of a building or conveyance. A verbal warning from the owner or authorized agent is needed, and unfortunately the bill language as originally filed contained a provision allowing churches to post a sign to prohibit firearms, violation of which was a crime. As written, a sign the size of a postage stamp would have sufficed. An unacceptable precedent giving signs the weight of law would have been set. Florida Carry brought that to light, and the bill was amended to eliminate that poison pill. Governor DeSantis has signed the amended bill into law. Recently, the gun control lobby has been using a new tactic, mooting a case in progress to avoid an unfavorable judgment. In particular, this has become a pattern and practice utilized by local governments and some state agencies to shield themselves from liability incurred under Florida's preemption law. Senate Bill 1884 was introduced by Senator Ray Rodriguez, tweaking the statute to close that escape route. Quote, if after filing of a complaint, a defendant voluntarily changes the ordinance, regulation, measure, directive, rule, enactment, order, or policy, written or unwritten, promulgated or caused to be enforced in violation of this section, with or without court action, the plaintiff is considered a prevailing plaintiff. That's going to head off a lot of problems. That's the legislature wrap up. Let's take a look at what we've done in the courts. In March of this year, Florida Carry scored a big preemption win against liberal Broward County. This years-long case challenged several county ordinances regulating firearms. The county attempted to sidestep preemption in two ways. First, by using the term weapons instead of firearms. This is because state statute defines the two terms separately. The argument was discarded by the Florida 2nd District Court of Appeal, as the county's own definition of weapons included firearms. Secondly, the county relied on disclaimers such as, provided that a person is licensed to carry or is carrying in accordance with the law. In the words of Judge Spencer D. Levine, writing for the majority, the, quote, provided that clause, end quote, attempts to cancel out the apparent regulation of firearms in the ordinance. By including the provided that clause, Broward County attempts to regulate indirectly what it cannot do directly. The case affirmed the order of the trial court finding Broward County in violation of state preemption, and as Hannibal Smith famously said, I love it when a plan comes together. Here's another legal hot potato we've been working on in court. Being an XPOC state, background checks for purchases are done by the Florida Department of Law Enforcement, or FDLE. Tens of thousands of purchases were indefinitely delayed without any action by FDLE. When counsel attempted to file on behalf of the folks whose rights were being denied, FDLE would immediately moot the case and destroy the investigatory record, claiming they had to in order to comply with Florida's anti-registry statute. Now, mind you, the records were those of the complainants themselves. Of course, this left the agency with immunity, and as a pattern and practice couldn't be established without the necessary record evidence. Well, the Florida 1st District Court of Appeal saw through it, ruled against FDLE, and stated record evidence necessary for such cases must be retained. That case is continuing. In a somewhat related case, The Department of Agriculture and Consumer Services, the carry licensing issuer here in Florida, was told by the court that they must afford an applicant the ability to refute any denial of a carry license through a formal administrative hearing, something the department hasn't done in 14 years despite a statutory requirement to do so. So you can see, our state organizations are the boots on the ground in both the legislature and the courts, but they need your support. When you stroke that check to support a national gun rights organization, please don't forget your state groups. I think Winston Churchill summed it up best, addressing President Roosevelt in 1941 regarding the Lend-Lease Act. Give us the tools, and we will finish the job.
Give this a try. Is this idea of interposition and placing these issues before the judiciary and arguing the limiting powers of the federal government versus the rights that are retained by the states. We retain the right to protect the right to keep and bear arms. We don't have to rely on the federal government to do that. So these are exciting times for us here in Idaho, and we feel that we have proposed something that may potentially be of interest to the United States Supreme Court if this actually gets litigated. And you know, the lawmaking process never gives us exactly what we're hoping for. Our first draft of this law was absolutely beautiful. It had everything we wanted in it. Through the sausage making process, we wound up with a bill that in a law now that wasn't quite as good. Things were left out that we certainly intend to pursue in the future, like requiring the Attorney General to challenge unconstitutional federal laws. They locked that one right out of there. But we have enough in the resulting law, the resulting sanctuary law that came out in Idaho in 2021, that we can make some really interesting arguments above and beyond these acts of defiance that are being passed in other locations. Stay vigilant, and we will certainly keep you updated on the AK show as things play out. As always, thank you for watching.
I did want to highlight briefly some things that have worked well for us over the past several sessions that you might be able to take away from our experience here in Minnesota. The first is to have a full-time presence at the state capitol. Our political director and lobbyist was there every single day lobbying on behalf of our members, answering questions and helping legislators message gun rights and gun control legislation. We hold a lobby day every year, and we've tried to make this the biggest event that we can. Our last lobby day, we had more than 800 people showed up. Makes a huge impression on both sides of the aisle because we vastly outnumber the lobby day held by the anti-gun groups. Make sure you send out press releases and get media attention as a part of that. Work to build allies in the news media. If you can get equal treatment and a quote in every story, you can ensure that your message doesn't get drowned out. Use video as much as you can. We have used Facebook Live more and more extensively to tell our story directly. In fact, almost every single day, we're broadcasting from the state capitol, giving an update, or from our offices here just north of the Twin Cities. We're launching a weekly show hosted by our political director that will help get folks more active across the state as we head into the 2022 elections. Make sure you're surveying and grading candidates and publish your endorsements. Back your champions that move your legislation with time, energy, and money to show them off, but also to show others that you will support and have the back of those who will go to the wall for you and our cause. Our organization continues to grow here in Minnesota with thousands of members and hundreds of new monthly donors, and we look forward to electing a pro-gun majority in 2022 and passing key Second Amendment legislation like constitutional carry and stand your ground into law. I hope you enjoyed the rest of the Gun Rights Policy Conference, and I hope to see all of you in person in 2022.
Good morning. This is Richard Pearson, Executive Director of the Illinois State Rifle Association. I'm glad to give you the Illinois report this morning. Illinois is always busy. We have several court cases going on. One of those cases is Brown versus the state of Illinois. And in this particular case, a disabled lady by the name of Vivian Brown was threatened by her ex-husband and acquired a .22 rifle for her personal protection, single-shot rifle. In Illinois, to own a firearm, you have to have a firearm owner's identification card. You have to have that to buy firearms, to have ammunition. Ms. Brown did not have one, and so someone called the police, and they came and arrested Ms. Brown, seized her .22 rifle, and arrested her. The public defender in White County argued constitutionally that the FOID card was unconstitutional in the home, and he won the case. And so the White County judge agreed with him that the FOID card is unconstitutional in the home, and that is now on the way to the Illinois Supreme Court. Ms. Brown is not financially able to handle this case, so the Illinois State Rifle Association is stepping in with attorneys and fees to pay her court costs. Should we prevail in this, they will deal a blow to the FOID card. It will be probably the beginning of the end of the FOID card.
They couldn't stand the fact that we were there, they were asking very valid questions about people's constitutional rights, and that message was getting out through our social media platforms, and people were responding to it. So I would like everybody to understand that we have to stay focused. We have to, this is not just a Second Amendment fight, this is also a First Amendment fight. You know, if you look throughout history, you know, why did they have big book burnings? Because the tyrants, the people that didn't want, the dictators and tyrants and people in charge didn't want any different views. And ultimately, those views were always siding with freedom and liberties that the oppressive governments did not want the people to find out about.
Back in 2019, Connecticut passed a firearms storage law called Ethan's Law that requires all firearms to be locked up, whether loaded or unloaded. This law is now being pushed on the national level. CCDL was strongly opposed to this law from the beginning. However, CCDL advocated and got an addition made to this law that the state shall develop a firearm safety curriculum for schools that local school boards can adopt to teach firearm safety in grades K through 12. With our advocacy, we were able to have our first school system adopt this program, and we have many other towns that will soon be following in this true safety measure.
The Firearm Safety Guide for Connecticut Schools is in response to the passing of Public Act 19-5, known as Ethan's Law, in 2019. A section of the Public Act required the State Board of Education to approve guidance for schools to develop appropriate firearm safety curriculum, educating students from elementary, middle, and high school. Contact your town, city, or regional Board of Education to encourage them to incorporate this approved safety guide in your local school district.
Currently, CCDL is in the middle of a fight with the state over a complete shutdown of firearms transfers. Back in July, the state attempted to upgrade their background check system, which has additional checks beyond just federal NICS. This was supposed to be done over just a few days, and we were promised this new multi-million-dollar system would be a much-needed improvement to make the system faster and more efficient. But the system was launched with tremendous technical and logistical glitches. This caused gun stores to spend countless hours a day on the phone trying to get a background check authorization number to sell just one firearm.
You have reached the authorization line during normal business hours. All representatives are currently assisting other callers. Please try back at a later time.
To date, some FFLs have had sales virtually completely depleted due to the inability to reach the state in order to get an authorization number. Additionally, the state simultaneously rolled out a new fingerprint system for permits. Police departments were not trained in advance or are unable to log into the new system, causing pistol permit applicants that need their prints taken in order to get a permit to be turned away. Residents are lining up at the state police barracks at 4 a.m. in an attempt to try to get their application processed. Most residents are being turned away once quotas are hit for the day.
On July 20th, 2021, the CCDL filed an emergency motion with the court seeking to stop the state's most recent and egregious constitutional violations. We are continuing to fight this absolute failure to provide for a reasonable process to be able to keep and bear arms. CCDL is committed to this fight, and we look forward to a victorious report on this time next year.
Hi all, I'm Diana Muller, coming to you from my dad's man cave in north central Missouri. For those of you who don't know me, I'm a retired police officer, I'm a professional three-gun competitor, and I'm the founder of the DC Project, Women for Gun Rights, and the Ambassador Academy. The vast majority of my life, if you had asked me, who is the gun lobby, I would have said, the NRA. For years, I would give them my annual dues and not think another thing about it. I was unaware of any of the other Second Amendment organizations or the work they did to defend the Second Amendment. I wasn't plugged in. I wasn't engaged. And with only 6% of gun owners participating in any kind of Second Amendment organization, I think it's safe to say that there's a lot of gun owners that aren't plugged in. A handful of years ago, all of this changed for me. I found myself sitting in front of my congressman and as a tourist, and the light bulb came on. I said, hey, is there something that we as pro-shooters should be doing to help educate the folks in this building that are making some pretty horrendous decisions that affect us all? That was the moment my Second Amendment advocacy began. I didn't know it at the time, but that was the moment I became the gun lobby. That is the moment that sparked me to pay attention and start engaging, getting plugged in. I was woefully behind and I felt a sense of urgency, but I had reached a point and I realized nobody is coming to save us. It is up to us. It is up to me. But how does somebody make a difference? Is it even possible to meet with your legislators? Would it be effective? The wheels start turning. And in the words of Cheryl Todd, if not me, then who? The wheels are turning, and I realize that women have a stronger voice when speaking on the Second Amendment since we break that stereotype of the typical gun owner. So I started reaching out to women in the industry. I only have standing in my home state, so I'm going to need one woman from every state, which was the initial goal. And that's where the DC Project was born. Fast forward to 2020, and we've asked those women to go back to their home states and execute the same effort at the state level. The DC Project has had some amazing accomplishments over the past several years. Every year we have a rally. Now, I'm not a rally girl, so this makes me extremely uncomfortable. But there's something powerful, there's something so cool about being on the lawn of the Capitol of the United States of America and being free to speak our minds. I would highly encourage you to attend a rally because, you got it, you are the gun lobby. Now, if you were at the 2019 Gun Rights Policy Conference, you know that I testified in front of the House Judiciary against an assault weapons ban. We knew that Moms Demand would be there in their signature red shirts. The DC Project came up with the Teal for 2A campaign. 10 ladies accompanied me to the hearing, dressed in our teal Educate, Not Legislate t-shirts, and sat right behind me. And it worked perfectly. Anytime the cameras were on me, you could see a sea of teal behind me. And if you've been keeping up with the Chipman nomination for ATF, he was sitting right next to me that day, so there's a good chance that you've seen some teal in his pictures as well. And that pink dress that was loaned to me by none other than the magnificent Julianne Versal right after I got off stage at the 2019 conference. As far as Moms Demand goes, the DC Project has organically become the counter visual and the counter voice to the red-shirted commie mommies. They are not experts in guns, nor are they experts in violence, and they do not speak for us. The DC Project was also honored to play an instrumental part in the testimony and the optics game during Chris Cheng's appearance in the Senate Judiciary this spring. We helped craft his testimony and made a statement in the room by coordinating not one, but two pro-Second Amendment minorities sitting right behind him. That's the reality of who the gun lobby really is. There's a misconception that the gun lobby is only made up of white dudes, and Mom's Demand makes it seem like all women are against firearms. But take a look at this.
The belief has been for a really long time that if you are not 6'2" with a beard and a plaid shirt, that you don't care about guns and you don't care about the Second Amendment. And what we found was that, guess what? We do.
So how do we influence? Legislators will tell you that it's exponentially more influential to get a visit from a constituent than it is from a lobbyist. That's why the DC Project continues to go to Capitol Hill and continues to forge relationships with our members and their staff. Our most recent trip this past spring, we took a small contingent due to the restrictions and had the honor of presenting to the GOP members of the Second Amendment Caucus and to the Senate Judiciary staff. Each of our girls told their story, which really provides armor for the pro-Second Amendment legislators to defend against the attacks from groups like Mom's Demand. Here's what Congressman Massey said about our visit.
There's some members who are here who they're pro-Second Amendment, but they don't really know how to articulate or how to motivate our argument for the Second Amendment. But these ladies actually gave us a voice today, and I know we're going to be able to make better arguments in our hearings, on the floor, in debates, and I know we're going to be able to hold the line because DC Project came here tonight.
Since that trip in April, 3 of our DC Project ladies have testified in a series of gun control hearings. Nikki testified in the Senate Judiciary against red flag laws. Ashley Lubinsky testified on ghost guns. And I testified in the House Judiciary on steps to prevent gun violence, where they were pushing background checks on ammunition, safe storage laws, and repealing the Protection of Lawful Commerce in Arms Act. Their attacks on the Second Amendment will never stop. And it's up to all of us to always be prepared to give an answer to everyone who asks you to give the reason for the hope that you have. And do this with gentleness and respect. That's 1 Peter 3:15. Effectively influencing our friends, our families, and our communities should be an intentional goal. But that can be difficult in today's climate. I feel like I'm preaching to the choir here because Gun Rights Policy Conference is the most effective event I've seen that actually helps attendees equip themselves with knowledge and the talking points. But I feel like, as a whole, this is an area that our side can improve upon. Knowing what to say about why you oppose universal background checks, knowing why you oppose red flag laws, that you believe education is the key to safety and not legislation. Knowing those things are critical. Training yourselves to articulate how gun-free zones kill and learn the stories like Nikki Gozier, who witnessed her husband being killed by her stalker in a gun-free zone while her lawfully permitted gun remained in the car. She was legislated out of protecting herself and left defenseless. That you are your own first responder, and backing that up by telling Melissa Schuster's story about getting stabbed 17 times, beaten in the face with a crock pot, and raped and left for dead in a stranger home invasion. She will tell you that the rape was the worst of it all. That gun rights are women's rights. Firearms are the great equalizers. Amanda Johnson was a martial arts trained concealed carry holder that played by the gun-free zone rules and left her gun at home while she went to class at a Nevada university. 100 yards away from the police station, an evil soul violently raped her at gunpoint. He went on to rape and kill his next victim. Amanda knows if she had been armed that night, she could have changed the trajectory of both of their lives. Tragic stories are not owned by the anti-gun side. We can use emotion as well to talk about why we never want to be defenseless, why we choose to carry, and why we support the Second Amendment. And let's talk about common sense and evidence. Let's use their words and shove them back down their throats. Common sense is seeing decades of evidence that gun control laws do not equal safety. Over the past 30 years, many American cities like Chicago, Baltimore, and St. Louis have all adopted extremely strict gun control laws, and they are leading the way in violence and crime. When citizens cannot defend themselves, criminals are emboldened, crime soars, and communities are less safe. Common sense is that cities that are plagued with violence should adopt the laws of the cities that aren't plagued with violence. Common sense is holding criminals accountable for breaking the law that are already on the books instead of releasing them from jail or encouraging them to be more confrontational like Maxine Waters did. Common sense is that guns and walls do work, which is why the Capitol was surrounded by both for months. During my last testimony, I told them that the hypocrisy did not go unnoticed. Where does one get to practice how to articulate these talking points? Whether to be a friendly podcast or a hostile interview. Where do you go to train to be better on camera? Where do you learn how to utilize and strategize social media and understand the analytics? How do I film and edit my own content? These are some of the questions that led me to start the Ambassador Academy. It's an intensive 5-day academy that brings subject matter experts under one roof to teach on a myriad of topics that makes you a better ambassador not only for your partners, but for the larger picture, the Second Amendment community. Each and every gun owner, each and every employee of a firearms company would benefit from this class. Our goal is to plant the seeds that will grow into more Dana Lashes, more Coleon Noirs, more Maj Tourés. Get the details at ambassadoracademy.info. Listen, we are in a messaging and information war. It's more important than ever to know how to articulate our position and positively influence your audience. Whether that be the janitor at the next conference you attend, or the person sitting next to you on the airplane, or even your legislators. If you would like some help with messaging, check out the landing page of the dcproject.info. There is a free one-page document that talks about effective communication. The silent majority can no longer afford to be silent. We have to start playing offense. In closing, here is my ask. Embrace your inner lobbyist. Get engaged. If you don't already know the names of both of your senators and your representative, look them up. Same with your state legislators. Same with your local government officials. Same with your school board. Save their phone numbers in your phone and call them often. You don't have to travel to Washington, D.C. to meet federal legislators. They have offices in their home states. Grab a friend and set up a meeting. Ladies, we would love for you to plug into the DC Project at your state level. And more importantly than you knowing them, make sure they know you. Why? Because you are the gun lobby. Have a great conference.
And it is the gun control wish list and implementation of that wish list. So that's what we're dealing with at the United Nations. And the question becomes, what can you do as an individual? The United Nations is about diplomats and countries. There really isn't a place for individuals to participate in that process. I love the UN. They talk about transparency, and yes, we have to be transparent, and we'll talk about it behind closed doors, but that's the UN. As an individual, the most important thing you can do, of course, is vote. The administration in charge at the time that these reports are being written has a great deal of influence over the employees at the Department of State and what they will accept in the reports and what they will keep out. So, getting involved in the elections is critically important. And the other thing is to realize gun control is really just part of a larger attempt to create socialism. And the other thing is to look at the larger picture and combat socialism where you can. I think it's important to look at how socialist regimes have taken control throughout the world, starting with the National Socialist German Workers' Party taking over Germany in the 1930s, following a simple model. It was the same model followed by the United Soviet Socialist Republic following World War II. What did they do? They took over the media. They took over education. They took over law enforcement. Once they had those under control, they also took over things like healthcare. And in the case of the Soviet Union, following World War II, food distribution. If you didn't follow the party line, then you would not have access to certain fundamental needs. Get involved. Get involved with your school boards. I think one of the great things to come out of the pandemic, if that's the right way to put it, is that parents started seeing what their kids were being taught, what teachers were instilling in their kids, and they were outraged, and they should have been. And so get involved with the school boards. Make sure that they are pushing curricula and agendas and not tolerating anyone who is doing anything but promoting liberty, freedom, democracy in the schools. In the case of law enforcement, if there's a civilian committee in your town, get involved. I think it's fascinating. One of the elements of socialist takeover is control the law enforcement. They haven't been able to do that in the U.S. Sure, the big city mayors appoint police chiefs in the large cities who will push that agenda, but the rank and file police officer is a staunch supporter of liberty and the Second Amendment. And so they can't control them. So what are we seeing them try to do today? They're trying to destroy them. And get involved with the citizens committees. Don't allow them to defund police. And in the case of media, sure, buy a network, but a whole lot cheaper and just as effective is don't listen. Turn it off. If nobody's listening, they have no influence. So, and now I'm going to leave you with that thought of how do you really get under the skin of a liberal? And it's really simple. Have fun. Have a great time. Head out to the range with friends, family, go golfing, go fishing, hiking. It really doesn't matter. Have a good time. Enjoy life, and I'll see you at next year's Gun Rights Policy Conference.
I'm Robert Young, Executive Editor of Doctors for Responsible Gun Ownership. We are the doctors who know guns. We are glad to be part of the Second Amendment Foundation family since 2011. Thank you, Alan, Julianne, and the whole SAF team for hosting the best gun rights advocacy event of the year. We are a nationwide organization of healthcare professionals and supporters who value honesty and human rights. Our leadership includes Drs. Arthur Shabinda, Project Director, John Adine, Membership Director, Sean Brodale, Outreach Director, Dennis Petrocelli, Forensics, and Kevin Zhang, Online Manager. Our Second Amendment activities are all volunteer, as we are all full-time practitioners. For 27 years now, Doctors for Responsible Gun Ownership has been fighting the politicization of gun policy by know-it-alls in our profession. We base our positions on and educate others using the best data-driven science available, which consistently supports the net gain to public health from American citizens exercising their right to keep and bear arms. We view our educational mission very broadly. We have provided policy background and amicus briefs in major cases like Emerson, Heller, Peruta, and Vollschlager. We publish position papers by our experts on issues such as easing access to suppressors, electronic medical records, and emergency protection orders. We have testified before national and state legislatures across the country and share our expertise with other activists. We advocate for your Second Amendment rights in written, broadcast, and online media. Fox News, CBS News, National Review, The Washington Examiner, and many others. We publish a blog on the web with new content regularly and maintain a vigorous social media presence on Facebook and Twitter so far. We strongly object to the notion that doctors have any right to ask patients routinely about gun ownership. That's an ethical violation and malpractice if it leads to harm. We run a service at 2adoc.com, that's 2adoc.com, to connect gun owners to medical providers who support the right to keep and bear arms. Discussing guns with them is usually a pleasure, though optional. So let's turn to DRGO's main driving issue. The medical establishment thinks it knows everything about everything, from gender identity to firearm safety. Now they're on to climate change, all in the name of supposed public health. The problem is they don't know what they don't know. Learning how to diagnose and treat illnesses and injuries qualifies us only in those areas. Public health interventions are very important in preventing infectious disease in populations. Such authentic public health work has led to far more healthy lives and fewer early deaths than any other human endeavor. Alongside this, developing medical treatments and preventive interventions have saved millions more lives. So why do doctors want to veer from this ancient, honorable lane? By and large, we don't. Very few physicians want anything to do with the political goals of our professional organizations. That's why the American Medical Association now represents less than 20% of American physicians, down from 80% some 50 years ago, when men were men, women were women, and doctors were doctors. But that leadership has become progressively more progressive as private practices have become mostly replaced by institutionally owned medical practices, and physicians have to meet insurance demands to get paid. These pressure providers to meet the agendas of those organizations, not just to do what is best for patients. And that, my friends, is the socialist progressive approach of modern medicine. These political agendas go back a long way. A top official at the Centers for Disease Control in 1989 announced they were, quote, going to systematically build a case that owning firearms causes deaths. The head of the CDC in the 1990s, Mark Rosenberg, said that guns need to be seen as, quote, dirty, deadly, and banned, just as was done about cigarettes. He sought, quote, a long-term campaign similar to those for tobacco use and auto safety to convince Americans that guns are a public health menace. Of course, unlike cigarettes, firearms, like automobiles, used as intended, harm no one. Leaders of other specialty groups piled on. These are quotes. Guns are a virus that must be eradicated. Data on risks are not needed because guns have no redeeming social value. I hate guns. If I had my way, guns for sport would be registered and all other guns banned. The first salvo came in 1993 from Arthur Kellerman and Frederick Rivara, both gun control proponents. Their research, underwritten by the CDC and using dubious statistical methods, claimed that the mere existence of a gun in the home increases residents' chances of being murdered by 270%. This is still widely quoted and even exaggerated, and is a classic example of the contortions anti-gun researchers employ to scare people. This group looked at homicides in households from just 4 urban counties nationwide, which were then suffering high rates of violent crime. They assessed the presence of guns after the fact, often based only on neighbors' suspicions, and did not distinguish between those that were legally owned, illegally possessed, or just left at a crime scene. Not one of the identified firearms could be proven to have been a murder weapon. This is the sort of rubbish that anti-gun studies keep producing. In 1994, DRGO's founder, Dr. Timothy Wheeler, testified with other experts before the House Appropriations Subcommittee responsible for funding the CDC. The result was the Dickey Amendment that forbids not research, but the use of government funding to advocate for gun control, just as the CDC was doing. In 1995, Gary Kleck and Mark Gertz published their seminal paper showing that American gun owners used firearms in self-defense as many as 2.4 million times a year. In 2018, Kleck published a follow-up, having discovered that following his original study, the CDC had surveyed people on the same question in 1996, 1997, and 1998. Along with many other surveys since, the CDC's confirmed Kleck and Gertz's original findings. Oh, and by the way, the CDC never published its surveys. The same characters are still at it. In 2019, Rosenberg was still calling, quote, to appropriate funding for the CDC to restart its gun violence research program. And Frederick Guevara is still churning out anti-gun publications. Now, new CDC Director Rochelle Walensky wants to fund more gun-related research. She says she's, quote, not here about gun control. I'm here about preventing gun violence and gun death. Well, we hope so. But given the CDC's confusing and often contradictory advice about COVID, and even claiming the power to stop evictions as a public health measure, expect that message to change capriciously. Many of us will recall the, quote, assault weapon ban of 1994 to 2004. Subsequently, the DOJ's Justice Institute, the FBI, the National Academy of Sciences, and the liberal Rand Institute, as well as others, concluded that there was no good evidence that it had decreased suicide, accidental shootings, mass shootings, or violent crime 1 iota. Yet the civilian disarmament complex wants to ban them again. In 2014 and 2015, studies from Pro-Control Daniel Webster and the Johns Hopkins Bloomberg Center for Gun Policy and Research claimed that after Missouri ended universal background checks and became a shell issue state, quote, gun homicides increased. They also claimed that when Connecticut instituted universal background checks and became a May issue state, gun homicides dropped. That was true, but their own data also showed that gun homicides in Missouri had already been increasing, then did so at a slower rate following the change. Similarly, Connecticut's gun homicides were already dropping, but did so more slowly than before its change. That means that shall issue makes a state safer than may issue. Deceptive, manipulative, distorted, and not scientifically valid. In 2018, two noteworthy studies kiboshed the notion that background checks reduce violence. From UC Davis, ordinarily anti-gun Garen Wintemuth's group reported that the decades of California's comprehensive background checks, the most rigorous in the country, had no effect on its rates of homicide or suicide using firearms. And in 2019, DRGO member Mark Hamill's study was published showing that nationwide, concealed carry laws did not correlate at all with state-level differences in homicide or violent crime rates. So why still the cry for universal background checks and the fear of citizens bearing arms? Quality research has demonstrated conclusively that gun ownership in America is good for public health. The best work comes not from medical researchers, but from criminologists, such as Gary Kleck, Gary Mauser, and many others, and economists, such as our colleague, Dr. John Lott, whose Crime Prevention Research Center has done more to verify the safety and utility of civilian gun use than anyone. We need to keep it coming. Science is not a definitive oracle. It is a process that requires fair minds, openness to criticism, and a willingness to change beliefs as research yields new information. These traits seem sorely absent in most of the gun control industry. At the least, careers depend on continuing funding from the Bloombergs, Soroses, their allied schools, foundations, and organizations, and the government, none of which value individual responsibility at all. It doesn't take a graduate degree or statistical expertise to see the faults in advocacy research. You'll find, if you look, personal bias and cherry-picked data and interpretation. Correlations passed off as causation, using irrelevant analogies and false attributions. Inanimate firearms treated as if they are causes of shootings, casting blame and vilifying those who disagree. Irrelevant questions and straw arguments used as diversionary tactics. Data requests from other investigators being refused. Statistical significance purporting to have real-world importance when it doesn't. Finally, don't let disputes between us so-called experts distract you. The truth is out there, and without any reasonable doubt, the facts are on the side of common sense, liberty, and individual responsibility. The ultimate basis for our right to keep and bear arms is not science, but principle. We have the inherent responsibility to defend ourselves and our loved ones, and we are entitled to arm ourselves with the tools that enable us to do so, wherever and whenever. Please check us out at drgo.us. Thank you, and God bless us, everyone.